Hello, my name is David Henry and I am a practicing barrister and associate at McDermott Will & Emery in Brussels. Today I will be talking to you about the fundamental tenets of the new EU Damages Directive and some of its implications going forward. By way of overview, I will start with a short introduction, followed by what the implications are for businesses. I will then turn to some of the key tenets of the new EU Damages Directive. I will be looking at the right to full compensation, proof of infringement, limitation periods under the directive, the issue of joint and several liability. Then I will turn to disclosure of evidence, the passing on defence, quantification of harm under the directive, and the issue of consensual dispute resolution, or CDR. Before I end the presentation with a few final words, I will say something about collective redress under the recent recommendation of the Commission in 2013. So, by way of introduction, the EU Antitrust Damages Directive was formally adopted on the 10th of November 2014 and signed into law on the 26th of November 2014. Member States have approximately 2 years to transpose its provisions into national law. Specifically, Member States must implement the directive by the 27th of December 2016. The provisions of the directive will apply from the 26th of December 2016, but will not apply to any actions brought before that date. The EU Damages Directive is part of a package of measures aimed to facilitate antitrust damages actions in the EU. This package further includes a non-binding practical guide for national courts on the quantification of antitrust harm, and a non-binding recommendation on collective redress mechanisms. At its core, the directive seeks to harmonise certain procedures across the EU for claimants seeking to bring damages actions for harm caused by businesses found to have violated the EU competition rules. And via this piece of legislation, it's hoped that antitrust damages claims will be encouraged and facilitated, especially by businesses and consumers that have incurred loss as a result of cartel conduct. The Damages Directive will lead to significant change in antitrust enforcement, especially in those countries where claimants have found it difficult to gather the evidence required to substantiate a claim for damages, or face procedural hurdles to the successful prosecution of a cartel damages actions. That being said, it should be noted that there are many cartel damages actions before the courts in the EU. This is particularly the case in the UK, in Germany, and in the Netherlands, which have sophisticated regimes in place, such that the Damages Directive will have a more limited impact in these jurisdictions. This presentation does not seek to cover the Commission's recommendation on collective redress, nor the guide for national courts on the quantification of antitrust harm. As I already mentioned, I will, however, make a few comments on the recommendation towards the end of this presentation. So, what are the implications of the new EU Damages Directive for businesses? Well, the directive is of relevance, or indeed importance to you, for example, if you have been involved in an antitrust infringement, or are currently subject to an antitrust infringement investigation. The Damages Directive is also relevant to you if anyone in your supply chain has been involved in an antitrust violation. You may be able to bring a claim if you believe you have incurred loss, or you may become involved in disputes between other companies in your supply chain if any losses will pass through you, for example. For cartel defendants, two of the most significant implications of the directive are increased damages risk in the EU as a direct result of litigation, or what is indeed more likely, as a result of settlements following the threat of litigation. Leniency applications will take on an increased level of complexity, and I will elaborate on this in the main body of the presentation in a few moments. What I can say up front is that the failure to get the strategy right with respect to damages actions can first cost money, second cost management time, third disrupt the business, fourth damage ongoing customer relationships, and finally, but importantly, damage your company's reputation. So, looking at a few of the key tenets of the new EU Damages Directive. Underpinning the new directive is the principle that anyone who has suffered harm caused by an infringement of EU or national competition law has the right to claim full compensation from businesses found to have infringed the antitrust rules. Full compensation covers actual loss, loss of profit, and payment of interest from the time the harm occurred until compensation is paid. Both direct and indirect purchasers of the goods or services sold by a business found to have been in violation of the EU antitrust rules can claim compensation. As a result, both the cartelist's direct customers and those customers to whom products are subsequently resold by the customers can claim against the cartel infringers. In order to be successful in its claim for compensation, an indirect purchaser must show that it suffered harm as a result of the infringement. In this regard, it can rely on a rebuttable presumption included in the directive, which states that an indirect purchaser will be presumed to have suffered loss where the defendant has committed an antitrust infringement, the infringement resulted in overcharge for a direct purchaser of the defendant, and the indirect purchaser purchased the goods or services subject to the infringement from the direct purchaser. A few words on proof of infringement. Well, a final infringement decision of a national competition authority is binding on the national court of the same member state for the purposes of a follow-on damages claim. An infringement decision of a national competition authority in a different member state to that in which a damages claim is brought serves only as prima facie evidence that an infringement occurred. Turning to the important issue of limitation periods under the directive. Well, under the directive, claimants must be given a period of at least 5 years to bring their claim, and that period may not commence before the infringement has ceased and the claimant knows, or can indeed reasonably be expected to know, of the behaviour and the fact that it constitutes an infringement of the antitrust rules, that the infringement has caused harm to the claimant, and the identity of the infringer. The limitation is to be suspended where a competition authority launches an investigation or proceedings relating to the infringement, which is the subject of the damages action. And the suspension should remain in place for at least a year following a final decision or the termination of any such proceedings. Now, in my opinion, which is, I think, widely accepted, is that these rules will potentially open the way to claims covering many, many years of competition law infringements. A few words on joint and several liability. Well, under the directive, companies which have infringed the competition rules through joint behaviour, such as cartel conduct, are to be held jointly and severally liable for the entire harm caused by the infringement. Now, a corollary of this is that a claimant can bring a claim against just one or against several of the infringing companies until the claimant has been fully compensated. For infringers, this means that even if they are not sued by a claimant at the first instance, the possibility remains that another co-infringer may seek to recover a contribution for its share in the infringement. Note, in certain circumstances, small or medium-sized companies that did not lead or coerce others will be liable only to their own direct or indirect purchasers. Immunity recipients are accorded special status under the directive. What do I mean by immunity recipients? Well, in a nutshell, those companies that were the first to confess to an antitrust infringement and receive immunity from fines. So, as mentioned, immunity recipients are afforded special protection. In the event that an immunity recipient is sued for damages with respect to its activity in a cartel, its liability is limited to the harm it caused to its own direct and indirect purchasers and providers, unless full compensation cannot be obtained from the other entities involved in the violation, in which case the immunity recipient will remain fully liable. Turning to disclosure of evidence under the directive. So where a claimant has made a reasoned justification supporting the plausibility of its claim, national courts must be empowered to order a defendant or a third party to disclose relevant evidence in their control. Specifically, national courts must be able to order proportionate disclosure of specified items of evidence or relevant categories of evidence, which should be defined as precisely and as narrowly as possible. Where this requires the disclosure of confidential information, national courts must have at their disposal measures to protect such information, such as powers to establish a confidentiality ring, for example, where only specific individuals, such as legal advisors, can access the information. It's important to note that under the directive, leniency statements and submissions aimed at the settlement of a case are to be granted absolute protection from disclosure. This means that they can never be disclosed in damages actions. Information prepared specifically for the proceedings of a competition authority or prepared by a competition authority to send to the party in the course of proceedings, as well as withdrawn settlement submissions, are granted temporary protection from disclosure and cannot be disclosed until the competition authority's proceedings are brought to an end. It should be noted that under the directive, courts must be able to impose penalties for failure or refusal to comply with any national court's disclosure order, for the destruction of relevant evidence, for failure or refusal to comply with obligations imposed by a national court order protecting confidential information, or for the breach of limits on the use of evidence. The damages directive also deals with the passing on defence. As mentioned, the directive makes provision for claims both by direct purchasers and by indirect purchasers, i.e. intermediate customers and end consumers further down the supply chain. Now, where the claimant is the direct purchaser, the directive allows the defendant to invoke what is known as the passing on defence and argue that the claimant, its direct customer, has passed on the cartel overcharge, whether in whole or in part, to its own customers. And here the burden of proof lies with the defendant. Now, in this regard, of course, it's important to ensure the consumers benefit. However, the decision to confirm the existence of the so-called passing on defence does leave a problem. Well, what is this problem? The problem is that many claims are likely to be too small to pursue. And this must be seen against the fact that this is particularly the case when few member states have effective class action regimes in place. The directive also deals with the issue of quantification of harm. Specifically, in the case of damages in cartel cases, the directive introduces a rebuttable presumption that a cartel caused harm, although it does not stipulate how much harm. Now, this presumption is based on a finding that more than 90% of cartels cause a price increase. The practical upshot of this, of course, is that it should serve to reduce claimants' costs by removing the requirement to prove that a cartel caused higher prices. However, for defendants, this change will likely result in more defendants paying damages to claimants, higher payments being made through settlements, for example. Ultimately, more actions are likely to be brought. In all cases under the directive, and not just with respect to cartels, national courts will have the power to estimate the amount of harm suffered when it's practically impossible or excessively difficult to quantify the precise harm suffered. The directive also deals with consensual dispute resolution, or CDR. Now, the directive seeks to promote the use of CDR, which is generally considered to be a cheaper and faster way of resolving disputes, and CDR may involve out-of-court settlements, arbitration, or mediation, for example. National limitation periods should be suspended when parties are involved in CDR, and national courts will be granted discretion to suspend proceedings for up to 2 years where the parties are engaged in CDR. Under the directive, in order to prevent settling co-infringers from being placed at a disadvantage, they will not be held jointly and severally liable for awards of damages made against non-settling co-infringers, unless those co-infringers are unable to pay the compensation owed. To To ensure that claimants are not overcompensated, national courts must take account of any consensual settlements relating to a particular infringement when making an award of damages. A few words on collective redress. The directive does not address the issue of collective redress. However, on the 11th of June 2013, the Commission adopted a recommendation. The recommendation on collective redress is also aimed at facilitating access to justice and the provision of redress where there is a violation of EU law and not just competition law. Under the recommendation, the approach is that Member States should, although they have no obligation, have a system of collective redress that allows private individuals and entities, especially SMEs, to seek court orders ceasing infringements of their rights granted by EU law, so-called injunctive relief, and to claim damages for harm caused by such infringements, so-called compensatory relief, in a situation where a large number of persons are harmed by the same illegal practice. The recommendation deals with a number of principles, and these principles pertain to legal standing, admissibility, availability of information, reimbursement of legal costs of the winning party, funding, use of the opt-in approach for collective actions, lawyers' fees, and the prohibition of exemplary damages. The Commission intends to review the implementation of the recommendation on the basis of practical experience by the 26th of July 2017 at the latest. Following this review, we could see a piece of hard law with respect to collective redress in the future. So, a few final words. Well, following the implementation of the directive, I think we're likely to see many more damages cases being brought, especially in those jurisdictions where there have been very few claims to date, noting that there are many ongoing cases in jurisdictions such as the UK, Germany, and the Netherlands. It should also be borne in mind that currently only 25% of Commission decisions finding a cartel or indeed any other antitrust infringement are followed by damages actions. In this context, I believe that the UK will in fact continue to be the forum of choice going forward. So what does the directive mean for your business? Well, in practical terms, I think it's imperative that you have sufficient legal, financial, and human resources in place in order to assess your risk and come up with an overall strategy to deal with the increased likelihood of claims, which may stretch across many jurisdictions. In fact, the bottom line is that you should, indeed strongly recommended, that you have an effective and up-to-date antitrust compliance program in place. As I mentioned at the beginning of the presentation, failure to get the strategy right with respect to damages actions can cost money. It can cost management time, disrupt your business, damage ongoing customer relationships, and damage your company's reputation. And with that, I bring my presentation to a close. Should you have any further questions, please do not hesitate to contact me on dahenry@mwe.com. Thank you very much.